share of my hand. I'd really love to say things just ain't that bad. Oh, how we love our denial, a comfort to cover up the shame. But the truth is standing on trial, and I've got proof that we're all to blame. Oh, my fellow Americans, are we reaping our harvest of greed? Have we built our house on sinking sand? Why are we being ugly Americans?
Good morning, this is CJ Holmes, founder of Homeowners for Justice, your host today for Weekdays Live. And boy, do we have a good show today. We've gotten feedback from yesterday's streaming of the Washington debate and the Senate Finance Committee there on a new law that they're thinking of passing. We're going to hear from a person against the law and why. So this is fabulous. We're actually going to be discussing what is going on, hearing both sides, so that everyone else can understand that there are two sides to every issue. And so Karen's going to be joining us for that, and we're definitely going to hear about this fraud. If you ever thought that it's deadbeat homeowners, I'm sorry, it's deadbeat lenders. These are the ones that have planned this deception from years ago, starting in 2007. We're going to hear all about that. I've invited Alvy to join us about the deposition, about the patents, about how that works. But before we talk about that, oh, and here's the connections again for everybody, just in case, so that we can focus on connecting with these people. At this point, they're standing up for the people, so let's support them. But I really want to tell you, tomorrow's Update Friday, so please, any update whatsoever, good, bad, activity, foreclosure, a win, a loss, let's hear from everyone what is going on, because then we can better understand how we can proceed as a group to save ourselves. We really, the homeowners, we need to get the owners on board, and we need to save ourselves, because that's pretty much where we're at. I don't think anybody else is going to do it for us. And the battle front is on many fronts. Some people fight at the door, other people, trying to save the house, and other people are fighting legislation, like we're going to hear from in a minute. But before we start, I wanted to bring a couple of articles to your attention. One is the judge here has revived a multi-million-dollar mortgage-backed security, MBS, dispute against the bond issuers, which means the investors suing the banks for these securities and for lying to them about the quality of the loans. And by the time we're done today, you're going to understand what I'm talking about. When they start lying about the quality of the loans, which those of us that have been involved in this for any length of time know that they did, the investors are suing, and those lawsuits have been booted out of court because the investors, the banks have basically gotten a pass. But now these defendants, Novastar, Royal Bank of Scotland, Wachovia Capital, Wells Fargo, Greenwich Capital, and Deutsche Bank, these are defendants in this lawsuit. And this is a reversal that revives the dispute. The investors claim that the underlying loans originated by Novastar, sold off to the investment banks, cost money because, gee, they were bad loans. What a shock. And this is just another indication of the horrific cheating and fraud that the banks are perpetrating on everybody. They've stolen the people's, they made them toxic loans, they've stolen that future from them. They're now fraudulently foreclosing. We're going to see that. And again today, and then, of course, they cheated all the investors. They're cheating the IRS. They're cheating the government. They're winning because they're in the center, and we have to fight back and get them out of that. Here's one effort that I'm going to show. I don't know anything about this organization. Somebody sent me this petition. The petition seems like a good petition. And so please don't color me with the effects of these other organizations. Again, I'm looking for stuff that works, good stuff. And sometimes a person will have several opinions, and some you may agree with, and some you may not. And that's okay. That's how this country works. So if you feel inclined to sign this petition to basically say, boot Eric Holder out, please do so. And I know I've talked about having a petition page on Homeowners for Justice. I do apologize, I haven't gotten it yet. I've made a note. I will get that on my website soon, where we can just load these petitions up and people can look at them and read through them and sign the ones they feel inclined to sign. So this is just for your edification and for the help of the whole country. If we have a Department of Justice that thinks banks are too big to jail and they don't deserve criminal prosecution, then we need to get rid of those people. We need to put attorneys in position that will prosecute the banks and will go after them criminally, because that's the only way we stop this criminal activity. If they only have to pay a fine, I call it a fraud tax. They pay some modest fine on these billions that they make cheating everybody. They will never stop. That will only encourage them. So we have to stop them from cheating everybody. Now, I'd like to bring on board our first guest, who is on the con side. We heard evidently the pro side yesterday, and I apologize, I did not have time to listen to the entire hour and a half of this going back and forth in front of the Washington Senate Finance Committee on this issue. So I'm going to welcome Karen Pooley. Karen, this is CJ. Is this Karen Pooley?
Hi.
Thank you.
Hi.
Thank you so much for joining us. Here's Karen Pooley for everyone. And I'm going to play your witness, your testimony in front of the Senate Finance Committee on what we played yesterday. And thank you so much for contacting us about the con side of this law. So once I'm done with this, then I'm going to have you share more about what that law really is and what we missed yesterday.
Thank you.
Okay, so let's listen to the testimony.
Thank you very much. Now we'll have the con side, and then we got another pro side after that. So con, people who just don't like this bill. So Shelley Erickson, Karen Pooley, Val Renata, and Janet Reiner. Okay.
Hi, Chairman Holmes. My name is Karen Pooley. Senator Benton, I would like to address your question regarding why is this is still happening. The reason that this is still happening is that the escrow and title companies are not bringing the original note in to reconvey properties. What's happening is they're taking lost note affidavits, and they are taking an indemnity agreements between the bank and the title escrow to hold them harmless for this reconveyance. A simple solution to this reconveyance problem is a bill that mandates the original note come into title and escrow and before the reconveyance happens. You asked about a private note holder. You ask any title agency if they can reconvey a private note holder with a lost note affidavit, and the answer will be no.
They only do it on bank-held notes?
Yes. And I would like to also say Representative Goodman sent me an email right before the House hearing that said the House hearing was canceled after back and forth with him and other realtor lobbyists saying that this bill is not it's not written properly. The banking lobby has been opposed to 2 to 3 $14 assignments when we have asked for mandatory recording. Now we are authorizing 2 full $75 recordings added to the real estate closings. And I'm asking you, isn't this an additional financial burden to real estate purchases? And that's not even being addressed here. In addition, Representative Neely is co-sponsor of this bill, and he owns a title company in Eastern Washington. As far as I'm concerned, that is a major conflict of interest, and Representative Neely would not answer my questions regarding when these reconveyance problems have begun. I'm pretty sure that before you pass this bill, that question needs to be answered. This bill only provides a cover-up to the real problem. The entities that are reconveying that don't have authority to do so, that is the real problem. Now this legislature can see that the problems that we're having regarding homeowners describing the real party and interest not being at the mediation table and not coming to the foreclosure, the same situations are happening in non-default situations. So the real party and interest needs to come to the reconveyance table, just like they need to come to the modification table, just like they need to be foreclosing under the real party and interest. This is a bad bill. It is not awesome, and it does not help the homeowner.
Mr. Chair.
Senator Benton.
I want to ask staff to look into Karen's questions on this. The questions that need to be answered. So if you get with staff on your questions, I want to get answers from staff on those questions.
Thank you.
So Karen, so your issue is there's not enough in the bill, or you just don't like the bill?
My issue is that rather than trying to cover up the problems with reconveyance, which is what I believe that is going on here, I think a bill needs to be written saying the original note needs to come into escrow prior to reconveyance happening. A lost note affidavit and an indemnity agreement to reconvey property should not occur. And all of this is happening behind closed doors. No one sees this lost note affidavit. It is not recorded. It is simply on the title agency's back files. So you don't know if your property is being paid off to the correct party. And when I heard WAMU being thrown around, well, those WAMU loans have been securitized. And the reason that all of these problems are existing is because these banks have securitized these parties. And I would like to say that Chase, in my own instance, has now provided me 2 different mortgage-backed security interests for one note. I ask you, how does that happen? And there's many more people than just me that have been provided 2 different mortgage-backed securities for one note. These banks multiply pledge these notes, and that's really what's going on.
Okay, thank you.
Okay, Karen. So share with us. We really appreciate your testimony, and so exactly what is the bill trying to do, and expound on your objections to it, please.
Well, what the bill is trying to do is allow for I'm getting feedback in my.
Do you have live stream on?
It's
okay.
allowing the title agencies to file a document saying that the bank has been paid and it should be the reconveyance should be happen. However, that is to occur 120 days after the banks have been paid. And then 60 days following that 120 days. So we're now out 180 days. That's 6 months beyond the point where the banks have been paid. The banks can file an objection, and there is no way at that point other than quiet title to get that off your title report. So the banks can file an objection that they've been paid and they don't need to reconvey that property. The problem is, or what I think this bill has done, is just exposed the title insurance and the title companies have just exposed the problems. And you saw the explosive testimony of Stu Halson, and Stu Halson was the one that said, if you require the original promissory note to come in to be involved in reconveyance, none of you would be able to sell your properties.
Exactly.
That was the explosive testimony following my testimony.
Right.
And what I find so interesting is I submitted the next day to the senators post-closing instructions from Ticor Title showing that what was mandatory for a reconveyance to happen was the original promissory note and the original deed of trust to come in to reconvey. And then in parentheses, following both of those requirements, was they would also accept an indemnity agreement in replace of that.
Right, and I want you to explain.
Truly, what I had said in my testimony, and what I also told the senators, was that 3 people following my testimony did not refute.
That's right.
Testimony saying that they are reconveying the big bank reconveyances with lost note affidavits and indemnity agreements.
Right.
And I think silence is a huge indicator that I was absolutely correct.
Exactly. And Karen, I want to just interject here for the viewers. I have on the screen Doc X's price list for creating documents. And right here, because I remember seeing this is creating a lost note affidavit. For $12.95, they would create, plus shipping and handling, they'd create a lost note affidavit. So basically what Karen's talking about is that this law, so obviously the title companies, and it's always suspicious to me when the realtors want to support it because they are so often on the wrong side. They're against the people, they're for the banks. And so they want to...
Could I interject here?
Yeah, sure, go ahead.
In Washington State, there is 2 parties in the realtors that are conflicted, and we have a real problem at the Washington State level of the realtors. But there are big factions in the realtor organization that absolutely know what's going on, and so we have infighting within our realtor association to actually do what's right. So
and
I would like to give kudos to the people within the organization that are
absolutely.
fighting to
change
tooth
this.
and nail to
That's
get
right.
the truth out.
That's right, and I agree.
It's happening.
I agree. Here in California, the agents, the members that belong to the realtor organization are most of the time against what the organization itself does. So the organization takes the realtor fees and then pays the representatives to go to the state. So in her case, it'd be Washington, in my case, California. It's the same in every state. They have state contacts and they push for legislation at the state level. They also have national contacts and are pushing for legislation on various topics at the national level. And in general, most of the time, the organization, what they're pushing for, is different than what the membership wants. It's just it's insane, and it just really is truly bizarre to me that it is such a diversity. And I really do believe that the members, the realtor members that are for the people, that want to stop the banks and stop the fraud and stop the title companies from just sweeping this under the table with a legislation like this, will actually rise up and try to get some changes. So tell me, Karen, on this legislation, I heard them tell you that they wanted staff to look into your questions. So where are you on that?
I have called all day yesterday to all of the senators within the Financial Institutions Committee, trying to get comments regarding my lengthy email following Stu Halton's bombshell of testimony following mine. And I actually would like to read an excerpt from my email.
Okay, perfect.
And I said, dear legislators, I would like to highlight what the title lobbyist Stu Halton stated this afternoon in the Financial Institutions Committee hearing regarding HB 1435. He said that if this legislature requires the original promissory note to be required prior to reconveyance, that none of your properties will be able to be reconveyed. What Mr. Halton is also saying, that is, if you require the financial and title industries to reconvey property using the method that has been required for hundreds of years in contract law, which is providing the original note prior to reconveyance, you will literally stop commerce. That simple fact should tell you all more than what
That's
you need
right.
to know regarding the felonious business practices
Exactly.
of what has gone on in this past decade.
Exactly.
I think that's really important to understand, is this practice of providing the note, to escrow prior to reconveyance has been the practice for hundreds of years.
Right.
Not just 20, not just 30, but
Right.
hundreds of years. It's
Right.
in the UCC legislation, and most attorneys don't even want to go down the UCC because they don't understand it.
Right. Right. And any attorneys that are willing to stand up against the system and the judges that are ruling in favor of the banks has to really basically put his career on the line. And so either there's a lack of understanding, and or there is understanding and they just don't want to step up. There's a whole combination of things.
We also stated in testimony that there is a court case right now in our federal court in Western District, and it's McDonald v. One West Bank.
Yes.
And a banker representative from One West Bank, in the evidentiary hearing, admitted in open court that sometimes the notes get copied and sometimes those copies get endorsed.
And sometimes they, like we sold the Brooklyn Bridge multiple times. Oops.
Yeah.
Oh.
So it'll be really interesting to see what our legislature does, because our legislature has been very pro-banker, and our judiciary has been, 50-50. But our Supreme Court has come down with several rulings that I believe are upholding the rule of law. Well, several being Bain v. Metropolitan Mortgage, and the latest in Clem v. Washington Mutual Bank.
Can you send me those, a list of those, please? And if you do, then I can link them up onto the Washington Legal Action by State. I have a web page of that, and I like to link these lawsuits when I remember to do it. And I apologize. Sometimes I'm behind on what I claim I want to do. But we need, the fact is, when we can get these lawsuits circulating and people can read the writing, then that will encourage them to file lawsuits in their states, maybe using similar laws or similar reasoning. The point is we have to work together, and the more we can connect with each other in all these various states, the better off the people are. And the more we can get judges
before I go, I would like to encourage any Washington listener
yes.
To call their senator, and you can call them at 1-800-562-6000, and better yet, go on to www.leg.wa.gov. On the left-hand side of that website, there is a link to find your legislator, and if they could call their individual senator and just ask them to reject House Bill 1435, that would be really helpful.
Right. Here, I've got it up on the screen now. The Washington state legislature, I'll make sure, of course, that that gets into the comment section after the show. And literally, the people have to rise up. The people have to start paying attention to the fact that this fraud was planned years and years and years ago, and that's what Albie's going to be sharing with us in a minute. The banks actually have patents for this fraud, and it's just absolutely outrageous, but this is what's been happening, and this is, if you will, sort of a late level battle when, you know, fortunately, Karen and other activists are stepping up, understanding what basically the banks and the title companies are trying to do. And that is, in my humble opinion, they're trying to sweep the fraud under the rug. They're going to say, we'll accept, instead of the original note, and did you catch that? They won't do this for an individual investor. So if some private party loans, you know, a hard money lender, gives a loan, the person wants to sell, and that original note of that person has to go into escrow with the deed of trust so that it gets paid off. They have to perform according to these rules of property ownership that we've had in place for hundreds of years, except now this gives the banks a free pass. The banks don't have to do that. They can just have created a lost note affidavit. They can forge one of those for $13 and send it over to escrow. And then what is that indemnity? Do you know what that is? Can you explain that?
An indemnity agreement is basically an agreement to hold them harmless for any mistakes that are made regarding the transaction. And I would like to also bring up this because if you have realtors on the line that are doing this, we only found out what's going on by questioning closing agents. And I had realtors go in and ask the process and ask about indemnity clauses, and we got some post-closing documents, I think mistakenly, but it shows that these indemnity agreements are being issued. And I am now talking to my insurance commissioner, because let's think about that. If they are giving an indemnity every single reconveyance to hold title harmless for any problems regarding that chain of title, what that means is those indemnity agreements have to have some sort of cash reserve. And I don't think there is enough cash reserves to back these indemnity agreements.
Well, and it begs the question, and here's another question, Karen. If the banks are going to hold the title company harmless, then why are the buyers paying title insurance?
Right.
What's the point?
In addition, my thought, and I don't have this substantiated yet, my thought is that these indemnity agreements are not coming from like J.P. Morgan Chase Bank N.A. They might be coming from, Chase Home Finance LLC. And the difference there, if people don't know the difference between an LLC Corp and a National Association bank charter, an LLC Corp is limited liability.
That's right.
Corporation.
That's right.
But they're providing the indemnity agreement rather than the full, bank chartered National Association. That Chase Home Finance can be, has a limited liability, which that's a problem too.
Well, absolutely. So here you've got basically and I've talked about this a lot, the banks play these major corporation shell games. They know how to create a shell organization. So like you said, they've created, no doubt. And so I know people are watching, so let's figure this out, because this could be where we can hit. That might make a big difference, because if the title companies can't get indemnity, and of course the indemnity, what I'm hearing Karen say, and the natural and logical conclusion is the bank, the National Association, NA, would create a shell company, LLC, which would give out all this indemnity, except, of course, when anyone's sued, they just disappear. They don't have any cash reserves. They don't plan on really giving that insurance or any help to a homeowner, right? We know they're not going to do that. So it's just another shell game to be able to dump these properties that they have no right to dump, to get paid on them that they have no right to get paid on, to shove all the liability off onto the homeowner, because the title company is going to say, I'm sorry, we have an indemnity. So yes, you bought a title insurance policy, but not my problem. And
well,
so,
and I don't think a lot of people really understand that in their, when they sign a mortgage or when they sign a deed of trust, they are also obligated to defend that title. So when title reconveys, the homeowner signs a warranty deed warranting title. And so really and truly the only parties that are really on the hook for this is the homeowner.
right. And that's why at least in Washington, and I heard the Senate panel make somebody commented about the former owner, the seller on the property, having later to go back into quiet title action to clear title.
Well, and if you also go back to Stu Holmes, I go back to his testimony the entire time because it's such a shocking bombshell. In addition to him saying that no one could sell their property if the Senate mandated a promissory note to reconvey, he also said, and I quote, we aren't, what did he say? He said something like, we aren't releasing the note, we're releasing the collateral. And that in itself is another bombshell. So he's not releasing the note upon reconveyance, he's only releasing the collateral underlying the note.
Well, then why do they get paid? If you don't have to pay off the note to release the collateral, then why bother?
Exactly.
Exactly. Okay, look.
I was like, whoa.
Okay.
This is really big.
All right, Karen, this is what I'd like to do. I've been taking notes. People have been watching me. I would like, most people do not understand the actual steps of escrow and the transaction. So I would like to invite you back next week. Let's maybe on Tuesday or Monday or Tuesday have a layout of escrow, how that works. We're gonna bring up this Washington testimony and listen to these various pieces so that we can understand, the public that's watching can really grasp the bombshells that you're talking about, and how, and I've been saying this now for years, how this affects everybody in the nation. This affects everybody. This is not just people facing foreclosure. This is why I call it clouded title infection. They've just infected everybody.
Well, that's why I said before the committee, it was like they have just revealed these same problems that exist in the foreclosure, that the real party in interest isn't coming to the table.
Absolutely.
The same problems exist in the non-default world.
Right. And this is what the people need to understand and wake up to, that it's not just those deadbeat homeowners, if you want to buy into that myth. It's their title. It's their property. It's everybody's. Thank you so much for stepping up and contacting us. And we invite you back next week. I'll work with you after the show on what time, and we'll put that together for everybody for next week. Thanks, Karen.
Great. All right. Thank you very much.
You bet. And now I would like to bring on board Alvy Campbell, because feeding right into this discussion, he's going to share with us how far back this fraud, when it started, and what we know now that I wish we'd known about 4 or 5 years ago. Alvy, is that you?
Oh, CJ.
Hey, thanks for joining the show. Tell us a little bit about yourself. I've got your picture up now and what you're going to be sharing with us today.
Okay, well, thank you for having me, first of all. But,
anytime.
I came from more or less computer software backgrounds, working with certain computer corporations here in the Austin area. And, got involved in all of this. And from there is where I am today. A lot of research. I'm glad that I had that background to begin with. That did help me so that I could help others with it, to understand it. So with that said, there's a lot of research that's been done, and there's a lot of information to provide to people to help them better understand how to fight this and what not to go after, because there's confusion with all of this.
Right.
So I got I received the email and all about the depot and all. I want to clarify that and all. It's not a deposition, and this is kind of what I've been getting at in quite a few of the articles that I've written about words and knowing what they mean, because it's very important to us because of the way that the other side is using these.
Okay.
Deposition is not really the right word for that at all, but it is the minutes of the meeting of that
Right.
task force meeting that was in November of 2007, which was basically for the 735. These are Texas Rules Civil Procedure 735 and 736. It dealt with home equity loans that are protected by the Texas Constitution. So with that said, the people that are there, and another note I'd like to say is that Michael C. Barrett's been deceased since the early part of 2009, so I'm not going to speak disrespectful of him, but I will speak of the words that are used in this minutes testimony that they did to manipulate the laws, so to speak.
Right.
If anyone has read this and they go through and see that this actually, it started earlier, like in the 90s and all, when they were trying to add words into, say, the Texas Business and Commerce Code or the Property Code, such as servicer and so forth. There's a plan for all of this, because G. Tommy Bastian, who explains a lot about MERS in that task force meeting, he explains MERS in articles. There's one called MERS 92, something like that. But it's in 1992 that he was already explaining to people about MERS. And, we're talking about electronics back at that time, and most people didn't realize it. So hopefully this will help people understand that these people that we think are doing wrong, as far as our elected officials, there may be some that are doing that, but there are others. They were brought up with this. They were raised like a child was raised in a family, so to speak. This is the way they did things, and very few people are ever sent to go look at laws whenever they're hired somewhere. They're more to look at their policies and procedures. And I've explained this to some certain officials and all about why it's so difficult for them to understand is that they were raised up in it. I mean, they came into it, it was happening, they were unaware of it, and they were being told by the people that are manipulating this system. Those are the ones who trained all the people that we have, whether it's judges, the title companies, or whoever. They were preparing them for this electronic thing, but they were not supporting what they were saying with the paper, so to speak.
In other words, this deception was planned, and we're going to talk about that. I've shown the the transcript, and then I also have a specific in larger print the things that Michael Baggett said. But this was planned, and I think that was in 07. And so long before any of this foreclosure crisis really happened, because the crisis really started, I mean, as a realtor, I saw foreclosures really hit the market in 2008. So they had this discussion how they were going to handle this crisis and the paperwork before it happened. And if they were talking about MERS in 92, and I know that the actual legal opinion by Covington and Burling, Washington, D.C. firm for banks, was done in, I think, 98. I have it linked in my website. This is a long time coming. This is a natural and logical conclusion of the efforts these people have put forward.
Yes, they have. This was, it's brilliant how they did it. And if they had not gotten greedy, they might not have got caught as soon as they have. I think that they were probably planning on many years later on down the line on being caught. I don't think that they anticipated being caught right now. Because, again, this confusion with MERS and all is that MERS was designed to meet e-sign and UETA. And it was designed that way, and it works that way. It's not MERS, it's the MERS members who manipulate the MERS system. And it's taken place over some time, and that the 2007 transcript and all was showing that they realized that they had a problem.
Right. Let's go into that. Explain what they realized, and I'm going to show the specific planning and deception article. So what is Michael saying? What is going on here in this discussion? Because these, like you said, these are the minutes of what was happening in that meeting.
There was confusion. Apparently, if you go through and read it, start maybe about page 18, something like that, in the transcript and all, where the judges are talking about, they're interested in understanding MERS, and the main I would say speaker through this part of it and all was Tommy Bastian, and he's with Barrett Daffin. So he's the one who went through and kind of explained MERS to the judges and all, because if you look, I don't know, I believe it's around page 18 or 19, you'll see where one of them, Tommy, gosh, I can't remember his name, but you'll see it there. He's explaining how it used to work with paper. Back in the days, he said, was that the borrower went to Frost Bank, and the borrower made the payments to that. Whenever they paid that off, they knew Frost Bank was their lender, the holder and owner of the note.
Right.
But then he goes on to say that nowadays it's different because of the investors, the pools, and so forth. So they were already talking about these things being in pools, and they addressed that also as how do you present this to the court whenever it's in a pool and they really don't know who the owner and holder of the note is. And so they said, well, hey, we put servicer in the statutes back in 92, 93, 97, something like that and all, and so let's use that term. And we can give the servicer the ability to do the foreclosures and all, because they're the ones that know, who's supposedly the owner in the pool or the trust is. Well, that may be fine as far as electronics and all, but you've still got an owner and holder of note of an Article 3 tangible note.
Right.
So they decided that a single piece of paper would do it for them. This thing that they use now called the MERS assignment.
Right.
And that's their single piece of paper that they try to use. But if people would understand this tangible, intangible thing and all, and I'd like to point out a real simple explanation of that part. Karen, in her speech there with that counsel and all, whenever she mentioned that her note was in 2 mortgage-backed securities.
Right.
Okay? Now, go read Covenant 20 of that Fannie Mae security instrument where it says a partial interest in the note.
That's
You've
right.
got 2 interests that the note's been split into interests, and you've got 2 different mortgage-backed securities because maybe it's a principal-only interest and it's an interest-only interest that are in this. But that's that Covenant 20 that's in that security instrument that they're using. And if people would understand that and all, there you go. There's just some proof that that note was split.
Right. Oh, absolutely.
If you look at that, then, okay, that's the note. All right, they're claiming that to be the note. Then if that's the note, look at Article 3 of the Uniform Commercial Code, Negotiable Instruments, and look at 3203, 3.203, D as in Delta. You cannot transfer more or less than the full value of the instrument. So how did they do that?
Right. They broke it up in pieces. And so pieces are just strewn all over the place.
Yes, they are, and that's all the intangible parts. Stick
Right.
with the tangible, with the note
Right.
and the deed of trust, like Karen said about, you're to protect that deed of trust. Okay?
Right.
Good.
Right.
Now
Right.
look at the deed of trust. In there, you've got the laws governing the instrument, and if you have like Covenant 20 or the MERS part, where it's pointing out a beneficiary, so to speak, or that partial interest, this is being recorded in MERS. So that's going against applicable law. So if that's going against applicable law, that would mean, because of that Covenant 16, the governing laws governing and the severance part of it, when you read that any part of that deed of trust that conflicts with applicable law can be stricken from it or is not in compliance, I would say is a better word. So if you remove that, now only you have are the grantor or the borrower. You've got the lender that's listed on there, and you've got a trustee. You may have an electronic third party on there, but that part of that covenant or section that's in that deed of trust is stricken out of it, so how can they be there? We need to look at this tangible stuff and quit worrying about the intangible so much as you want to understand it because of the words that they use with it.
Right.
To understand what to do with that, what is supposed to be done with that paper note and with that paper security instrument. Because the note can be negotiated all along. They can do that all through MERS all they want to and come and collect at some point or whatever, but you're talking about just a note. If you're looking at it that way, you're not talking about the security instrument. Now, if you're talking about that note with that security instrument attached to it to secure it, now you're looking at different laws. You're not just looking at them being able to just assign it in blank somewhere, because someone has to know who has that, who lawfully holds that security instrument. And if you can't show that special endorsement or those endorsements along the way from A to D, then how can you show that properly or lawfully reflect that into public records? Well,
and see, this goes back to the discussion I've got up on the screen right now. What Michael Baggett had said. So finding a document that says, quote, "I am the owner and holder, and hereby I grant to the servicer the right to foreclose in my name," unquote, is an impossibility in 90% of the cases. And so this was what they were discussing in '07, right? How are we going to handle that? In other words, maybe they weren't using the tangible, intangible concept, but they understood that once they securitized these notes, it was over, and so they needed to somehow get this stuff back, right, into being able to foreclose.
Yes, and that's where they're trying to use like rules of evidence on copies to be able to just produce that because of it. Now, in the days like they were speaking about Frost Bank being the only bank, a copy may work, but the question is that if they say they have it, why don't they produce it?
Well, because it's much easier to just lie by words.
Why
I'll just say I have it.
Spend thousands or possibly millions of dollars on attorney to defend this when they could probably pay a few grand to provide that original note and all to show it and show proof that they are the owner and holder of that note lawfully. I mean, it's just pretty simple. I mean, if you had, if you wanted to go show that you paid someone and all that, you'd get your check where you signed it because the bank, after they cash it or whatever, comes back to you. You've got the proof there that you paid it. So if they've got the proof of the note, why don't they just show it?
Exactly. How tricky can it be if you're not lying? And that is the point.
I'm sorry, but the Mortgage Bankers Association back in '92 did a presentation on this. I thought it was beautiful. It was right in front of everybody's eyes and all. They showed the diagram, the flow pattern for all of this electronic mortgage things. And after signing and all, it's all scanned and then put into record. Well, that may be okay, but we're looking at an excluded from Article 3 and Article 9, basically. It's excluded from the Uniform Commercial Code, except 2 and 2A, 106 and 1.207, something like that. And so it's electronic. There are signatures required for that promissory note that they're using in the MERS system that has a MIN number that looks identical to the one that the homeowner has on a deed of trust, but yet it's a separate obligation by an account debtor. And what they did was they took and they said, okay, here's what we're going to do. We want to get you to agree that we can separate this deed of trust from the paper note and attach it to the MERS system. That's how MERS holds the title. The note goes to whoever. So you separated the note and the deed of trust at that point, but that deed of trust, that agreement to do that, allowed you to create, or allowed the originator, broker, whoever you want to call them, to create a transferable record to register on the MERS system. But to go with that, they needed a note, and so they used what they call an electronic promissory note, which is an obligation, and they attach that note to the transferable record. Or, as confusing as it is, you can attach the security instrument to that. But either way, what you did was you separated the deed of trust from the note because of the wording that's within the deed of trust, and then for them to have that e-note up in the MERS system and all the national e-note registry, they take the value from the note and they apply it, transfer it, if you will, to the e-note, the electronic promissory note, and they take all the borrower's information from the tangible instrument and they put it all in there. Now that would go with possibly with Article 3, 3203D, where they're transferring the full value of it over to an e-note. But how can they transfer it back?
Well, exactly. How do you make a carrot once you've pureed it? I mean, that's my simple, homemade analysis, because this is what they did. They pureed these loans. They've strewn them out all over the planet, and now they're trying to make carrots when they want to foreclose. And so I have up here some more of the not deposition, but more of the testimony from this meeting, the task force on the foreclosure paperwork. And this is another problem that I see, and then they refer to Tommy, that they talk about it regularly, and that they have a bunch of servicers that are corporations or trusts attempting to foreclose on behalf of other trusts using power of attorney, and I don't think that's really proper. And then they state right then, they all turn a blind eye to it, but they think it's an issue that out there somebody could use to potentially attack a foreclosure.
Well, we should, again, there's words here, and what you're talking about when you say servicer. What servicer are you speaking of? Because if you go and look at the 2007 white paper for the Mortgage Bankers Association, whenever they were explaining how the National E-Note Registry would work, it does not track paper promissory notes. There are only electronic promissory notes are tracked on that system. So therefore, it would be the MERS member and their responsibility for the paper and the tracking of the paper, because they're only tracking an electronic promissory note, a transferable record. But also in that, it describes the servicer, and the servicer is a servicer of an e-note. So now, if that's a servicer of an e-note, let's take Texas Property Code for an example, Chapter 51 in the definitions, where it calls the servicer. Would that fall? Would that person claiming to be a servicer, would they fit that description if they are dealing with electronic rather than real property?
And of course, my comment in all of this is, these guys in 2007, they didn't care about that. They were trying to do workaround. They were trying, I believe, from my take on this testimony, and I've not read the whole thing, but it really feels as if they recognized there were some problems. They wanted to come up with some way to make sure that that could be handled and they could skate through, basically. Is that a fairly decent summary of it?
Could. And all of that would be, you'd say, yeah, it's legitimate for them to do that and all, if they were doing it lawfully.
Right.
When you bring MERS into this and all, we're talking about a completely separate obligation that people did not realize was taking place.
Right.
So now they
Right.
can sell if they want to sell the payment stream or whatever, they can go through and do that through servicing or and all, as far as that goes. I mean, because it's just collecting payments. But the question should be is that if I've got a contract here that I signed, called a promissory note or called a note, and it tells me who I'm to be paying, why did someone else come along and tell me to pay them in their name because they call themselves a servicer?
Right. Right.
Because my contract is with the one, and so now if I'm paying this over here, if A comes back, we'll say American Mortgage Network, that's who I dealt with my note and all, is that what if American Mortgage Network comes to me and says, hey, you have never paid me a dime?
Right.
I don't have any proof of that other than what I thought I knew I was doing by sending payments to a mortgage servicer whenever they told me to give them to write it and put it into their name.
Well, and this is turning into the real nightmare in this country for everybody, and that is they make payments, but you have no way of knowing where those payments are going, if they're going to actually pay off your loan, if it's going to the right party, and if you paid it off, it'll actually get reconveyed. This is obviously the problem that they're having in Washington, is that, it's turning into a real mess and a nightmare for everybody.
It is, and that's why it's important. Precision, that word can't be drilled into someone so much and all to understand this, because it has to be, because they're manipulating, they're using the art of words.
Right.
Just like they use the art of war. They're
Right.
using the art of words
Right.
to manipulate people. People are assuming whenever they say the mortgage, or they say the servicer, or they say, any of the words, where did you get them to define any of that?
Exactly.
Assuming what it is that they said because you think you know.
Right. You make an assumption that may or may not be right. And so then, let's say it's not right. And so then guess who gets cheated? Well, it's the owner. Because the banks and the servicers have intentionally done this. Can you talk a little bit, Alvy, about these patents that I saw going around? They hit my email. I'm going to bring one up on the screen.
Honestly, I think it's kind of a waste of time and all.
Okay.
I mean, as far as people, if they want to try to dig in depth with it and all, I mean, there's other patents out there. There's a patent by DocuSign, I think it is, on the transferable record.
Right.
And all, but, again, you're looking at intangible stuff here. I mean, that's software.
Right.
Software, and all, and it's just their whatever way of accounting. Actually, if you go and look into it in depth, it looks like a way of manipulating things so that they could get some way to get a mortgage that didn't qualify into a mortgage pool. So that they
Exactly.
could.
Exactly.
But even if you wanted to look at any of that, and delve into it, where does that apply to real property?
Interesting. That is a very, very good point. Because again, in general, when we read these things, I've got the foreclosure. This is a system and method for electronic processing of default case files. So this would be for foreclosure paperwork. And of course, that link will be on the live stream comment section. So you're welcome to look at this. I also wanted to bring up, this is the patent for loan applications, and of course someone has already marked it up, but one of the things that really struck me is that it doesn't matter if the loan has been accepted or denied, the application, because each of the denied loan, here I'm just reading right here, each of the denied loan applications, oops, sorry, it jumped on me, back to the beginning here. Let's see, includes an indication of whether one of the denied loan applications is acceptable for syndication or securitization. So it doesn't matter if the loan application is good or bad, if it's been accepted or denied. They are what, securitizing the denied loan applications?
How they can, the patent's basically showing you how they're manipulating the system.
Well,
As that goes. Yeah, can it be used against them? I'm sure, there may be a possibility of that, but why? Again, we're talking about intangible stuff over there.
Right.
Stick to those two contracts that you have. You've got a note that was signed. That's contract. All those things fall under the statute of frauds, from my understanding. Now, not only did you have the note, which was unsecured until you signed that security agreement, the collateral. Now they attached that to it, and it became a note secured by real property. Now you've got these laws that follow not only the note, but also that security instrument. Look at the Uniform Commercial Code 9209 or 9109 D2 and D11. That the note or transfer, and all those are not governed in Article 9. It's a lien, and basically, like here in Texas, they don't have to file the security instrument, but the fact is they did file it. Now that they filed it, you've got local laws of jurisdiction where the property resides, and there was a law there that said any action after that recordation that affected that instrument must be recorded.
Are these being used successfully in lawsuits? Do you how can the people use this information to fight foreclosure or to get their house back, or what can they do with it?
Like I said in one of our previous conference calls and all, is that if you're not certain, first of all, you need to understand what governs that note that they're claiming on, and what governs that security instrument. You could look at Article 9 if you want to and all, but it's a contract and all, and they've recorded. So if it's recorded in public records, then, obviously your local government would be able to, they won't give you legal advice, but they could let you know what it is, what laws govern.
Okay.
What actions take effect, because if you look, like, say here in Texas in a property code, you got the eligibility of recordings, of a recorded instrument being recorded. And here's what I was explaining to my wife this morning about was that, they could take and she asked why they file these things. Well, they file it, if you look to be eligible for recording, there's only certain things that are required.
Right.
Notary, the signatures, the witnesses,
Right.
and so forth and all. But they don't look at what's inside that,
Exactly.
the body of that instrument.
Exactly.
And
They don't
also,
read it.
it could be eligible for recording, but does the wording that's within that recording they're saying is eligible, is it in or is it not in conflict with applicable law?
Right. Right. In other words,
'Cause-
you look at that document, that recorded document, and determine if what it says in it matches or doesn't match the law.
Was it really eligible? It may have been eligible for recording, but
Right.
the wording within it and all could possibly be disputed. But again, you'd have to go through and look at, at the laws of your state, to find these, because it's just like e-sign or UETA, Texas. I'm here in Texas, and I reference Texas a lot. And the reason that I do that is to show people that, look, go to your own state codes and find it. Don't rely on another state, and don't rely on the federal, because like here in Texas and all, I don't think they're particularly happy with using the current version of the UCC, and they provided their version, the Texas version of this, and it's similar. And
Right.
that's what they were looking for, was just for the states to adopt an equivalence to it, something that related to that. So I can go to Texas Business and Commerce Code Section 322, and I can find the Uniform Electronic Transactions Act,
Right.
which has e-sign within it because of the signatures. And so that's what, people should focus on their state and their laws, all the way down to the local, to see what there is that's available. And I assure you, I did a Google query for transferable record, and I think most all the states that have an equivalence to the UCC popped up.
Right.
It's easy
Right.
to find those things
Exactly.
if people take a look. But focus on that, on the security instrument is a good idea.
That's right. It's the deed of trust or the mortgage, not necessarily the note. They're just using default on that note as an excuse. Now, here, what Albie do you have to say about that comment that Karen made earlier today, where the banks just she was talking to a testimony to the Senate panel about the they're not releasing the note; they're just releasing the collateral. Does that? Is there anything that we should take away from that you can think of?
Well, what collateral are they releasing?
Well, that would be the...
You're looking at two mortgages. You're looking at a tangible paper mortgage, and you're looking at an intangible personal property mortgage. That's what MERS is. That's what that note registered on MERS is an electronic promissory note, a promise to pay electronically. It's not a promise to pay paper, tangible. It's a promise to pay electronically. So what are they releasing? What are they doing?
Well, I believe the whole concept was they're just since they can't come up with the original note, they can't prove who owns it to get paid. They're sidestepping that by just saying, okay, we'll just stop the effect of the deed of trust or the mortgage on that property that as collateral. We'll just release that, and we'll just forget about the note. That's how I interpreted that comment.
Well, that it is, and I believe that's a mentality of the old days, dealing with the new age. Because if you go back, I don't know if you saw, I did a little presentation called MERS Magic, and I went through and showed a chart of 30 years, a 30-year span of instruments being recorded here in Texas in Williamson County, to basically show people the difference between tangible and intangible instruments are being recorded, and the ones that were being converted through the 90s up until 2000 when the E-Sign Act was put into play. And through that, you look back 20, 30 years at a security instrument, it may be what it's called, but when you look at it, you'll see the note and the mortgage combined together with a separator page in between. That was the old tangible mortgage. So whenever they released the lien in public records, well, the note was being released also, a copy of it or whatever, however it was.
Right.
They would produce or provide that to you. Well, now all they record is a thing called a deed of trust, an intangible security instrument.
That's
so
right.
It's the way they look at it is they just release that and they've released everything else.
And don't bother us with having to prove anything about ownership on the note or anything like that.
Who's paid attention to the history of mortgages and how they were recorded, or what kind of actions took place? I mean, I had this argument with quite a few up in the judicial area about how is it that we'll say there's one case here in Texas that the banks love to use, and it's called Rice versus Piney. That was dealing with a first lien holder back in the days of paper. But yet these electronic mortgage people that are coming in and taking people to court, they're using that very case where this note and lien have been transferred, supposedly to many. They try to go back and use that case to justify what it is that they're doing. Well, how can you do that? Because it's a separate obligation. It's not even paper anymore. It was paper when the tangible borrower signed the stuff, but according to the Florida Bankers Association, 09-1460, I think it is, down in the Florida Supreme Court, or some of the Bankers Association's presentations and all, they're eliminating all the paper.
Right.
That was the whole goal for them to use MERS for, was to eliminate paper.
Right.
So they're using everything electronically rather than paper, and that's why they're having the problems they are with producing anything.
Right.
It produced it, it would not reveal a true negotiation through all of them.
And
I mean, it goes way deeper than that, because whenever you get into it, you look at pooling and servicing agreements or the MERS electronic tracking agreements and so forth, and you see where the note and the security instrument were already pledged before, possibly before the homeowner, tangible borrower, completed the
transaction.
Transaction and all.
Exactly.
So it's understanding that deed of trust, that tangible deed of trust, and what it is, and what conflicts with applicable law.
But it was
Conflict with that. How can that deed of trust be held fully enforceable? Partially? Well, yeah, they could do that with just the lender, borrower, and the trustee.
And so
could come to it and claim it unless they could prove the proper negotiation of the paper, not electronic.
But what I've heard you say basically today is that the people that were looking to try to help us get back to reality, the legal, accurate way of doing things, these people, entities, and so that would be title companies and judges, they have grown up or come to their jobs in an environment that already had these issues in play because of these discussion, like the task force on foreclosure that we started talking about, and the comments that these people had back and forth about, well, how are we going to actually do this paperwork and what are we going to do? And so if that's in 2007, long before a lot of people have actually gotten into the industry or heard these cases, then we're really fighting a different kind of battle. It like you said, it's like they don't even know there's a different way, right?
Yes, that's practically what I'm saying, and people should understand it. You know, there are some good people in our system, in our government and all, but they've been misled, right? And they've been led to believe it that way because, yeah, I mean, banking's been around for a long time. You know, I mean, it's been fought throughout the country for many years, many years and all, and they came to believe that what they were telling them was fine, and what they were telling them was fine if it was dealing with tangible. But whenever it got in, one of the things that they seemed to fail to mention, you know, and all, was how the tangible or the intangible and all would be related to that tangible as below it. Go look at the Kuna letter back in 98, 99, something like that, and all, where the Credit Union Association wrote their concerns about the e-sign and negotiable instruments. They're not there. They were wanting to get that kind of covered in the UCC, but that was never touched.
Right.
So there was never any support for that electronic note. So why do you want to go after something that doesn't have law to support it?
Well, and of course,
paper stuff and find out, you know, is this what you're talking about? Are you talking about this tangible note, or are you talking about an intangible note?
Right. And it, because that this whole concept of the tangible and intangible, the payment stream versus the actual note and deed of trust, and the different laws that apply, has created such an incredible cloud of confusion that most people don't understand, including judges and attorneys and people and owners. And of course, by allowing this electronic foreclosure paperwork and the use of MERS to assign to servicers the notes, then that's, I believe that's, and it's so lucrative for the servicers.
Those are electronic servicers. Be careful how you say that.
That's
so
correct.
Easy for us in conversation, you know, and we can, you know, you can tell me servicer and all, and I know what you're talking about because you're talking about what you once knew as a servicer for just the tangible side of it. But now, when you're speaking of MERS, Fannie Mae, Freddie Mac, or any of the GSEs, you're talking electronic. Go read Freddie Mac or Fannie Mae's e-mortgage guidelines and see, you know, because did you digitally sign your note?
Well, I think most
Receive any electronic disclosures saying that you were digitally signing that note. That's all in those mortgage manuals. I mean, that's part of the Disclosure Act and e-sign. So how can they be using something electronic like that was never disclosed to you for something that you have that was paper and tangible?
Exactly. The only thing that, let's say a buyer, when they buy the house or they refinance, an owner refinances, they go into escrow and they sign the paperwork physically. They sign real paper. And that's the only thing they sign. They don't sign anything digitally to a servicer.
They don't. I maybe receive some emails or something. Maybe they'd be cautious with that because of you signing you out. But, you know, I mean, as far as that goes, the rest of it, they're using intangible type material and or goods and services, and you don't have that. You have real property. You have a note, a tangible note that's secured by real property. Laws follow that. If they would have followed that through the MERS system, everything may have been fine.
Right.
They
right.
didn't. You know,
right.
But again, that up there, you look at MERS, all right, that's it. We'll set that at the top. Envision this as just a little box at the top with MERS. Underneath, picture your note and your deed of trust. Okay, so that e-note is there in MERS, and those two are supposedly attached to it as a payment stream to the MERS member, whoever that is, the holder of the e-note, that electronic goods and services note that they have up at the top. And you make payments up through there and all. Well, they may move that around, that electronic note up there, but does that mean that the actual tangible note or tangible security instrument ever moved anywhere? Now, what they're claiming, MERS members, is that, you know, they're transferring a note, but what note are they talking about? And if it's the real note, the paper tangible note, where are the endorsements? Why is it not so hard for you to show that to us?
Right.
Because they're using electronic signatures by, excuse me, by taking the electronic promissory note and they're assigning it back and forth, calling it beneficial interests in, whether it's servicing or beneficial in the transferable record itself. But again, that's all something completely separate. Doesn't matter what they do with that. You stick to your contract. You stick to both your contracts. They're combined. They made a secured debt. If it's not secured, okay, come to me and claim that I owe the debt. Show me that note and all, and I can pay you. But if you have this note after it's been passed around to 4 or 5 people, where is that chain of title? Show me those chain of negotiations for that. Otherwise, you can only collect against me for the debt, and you're not going to take my real property, and that's all by operational law. That's not legal advice to anyone, so try and understand that we're dealing with a paper note and a paper security instrument and the laws that govern both of those. And whatever they want to throw at you, you stick with that part. And if they give you mortgage servicer or mortgage or nominee or whatever, clarify that.
Force that information out of them. And so now we talk about, you know, how do you force that information out of them? And so the qualified written requests, or like yesterday, Renee's going to try to use small claims court to get information out of them, whether that will work or not. This is the point. And I've got up on the screen now your chart, you know, the securitization using MERS for Fannie Mae. How the,
yeah, you could look
yeah.
at, I'm not at my computer. My wife's
that's
watching
fine.
the show, so I wanted to get away from the sound
That's
feedback.
right.
But if you're looking at the Williamson County chart from like 86, I think it was, to 2012, and you look around 92, 93, you see up to that and all, there was how you would see an average as far as the amounts of assignments were there. And then around 93, you'll see it almost double and go from there. That's where the whoever they were going through and converting the old deeds of trust that were recorded into public records and converting them into electronic deeds of trust or intangible deeds of trust by way of assignment or whatever. And you would see that go through and fluctuate through just about 2000, I think. And right around then, you know, they had pretty much hashed out conversion of the tangibles to intangible, and they had a security instrument that already worked, because if you go look back in the 80s, the Fannie Mae security instrument 3044 with Covenant 20 is there. sign came into place, now they could utilize that, or they thought they could.
And so literally, what it sounds like from the history you're explaining and the discussion and the diagrams is that this is like they tried one thing and it worked, and so then they kept it was like a draft. They drafted and then they redrafted and redrafted and literally got a system set up. And 2000 is an interesting number to me, the year 2000, because I have other contacts, and this one contact had a large company that he ran, and they did all of the title documents behind the scenes of all the escrows for the banks, and his business just literally died overnight, and he didn't understand what was going on. And now we discuss this and we look back and we say, well, what was going on is what you're talking about today, Alvy, had hit maturity, and so they just knew how to do it. They didn't want anybody else that really knew how it was supposed to be done or how it used to be done involved, and they just started doing this with MERS and the securitization process.
Well, sure. Think about this for a minute. Here we were in an age that we had back, we'll say the 70s and all. We heard the word computer. We didn't really know what it was. And then as it progressed and all, we're like the old 8086, 8088 computers came out, the first desktop, so to speak, that, people were fascinated with it. Wow, it's electronic, now they can do things like this and all, and they were so overwhelmed with the electronic side of it and all, it's like they forgot how they used to do it with paper.
Well, and
these guys who went through and set all this up, and like I said, there's plenty of them. I found one article really interesting and all that Tommy Bastian with Barrett Daphne did. He called it Republic of Texas paper terrorists. If you go through and you read this, or you didn't get any history on this, because for some reason I was pinned that at some point, being called a Republic of Texas person, and all. I don't have a clue what they are, but I've learned a lot as far as why that word's used, because they were placing liens on, various judges or whatever, and whoever officials and all, and so they had to come up with a way to clear that lien up. And in Texas, they did in the Texas Government Code. In Chapter 51, under the clerks and all, they did a section called 901 through 903, where a borrower or obligor could take, if they had found an instrument in public records that was, they felt was fraudulent, or I forget exactly how the wording is and all, but they did not believe that was eligible or qualified to be recorded, they could take that to their district court. And it provides the whole steps, the whole process for those to go through and do that and all. But those guys are the ones that instigated that type of stuff for it to take effect here. But from what I see, they turned right around and used what they were warning other people about, and they were applying the same similarities with what they're doing, and they became the new Republic of Texas paper terrorists.
Right. So you in Texas, there is a method that owners can use to actually take a document that they think is fraudulent or shouldn't be filed on their property and go to district court and get it removed?
Well, that's according to the statute, and that's Texas Government Code, Section 51, or Chapter 51, Section 901 through 903. 901 actually gives the clerk these abilities to do this, and I think this goes back to what I was saying in one of our previous conference calls, where that we need to educate.
Do you know of any?
If we don't educate these people that, look, this is what your law says. Because they've been following policies and procedures and through all this electronic world, and even though they're trying to defend it in certain ways, because I can go back and look through opinions from the Texas Attorney General where these questions have been raised about this.
Right.
And you have these people who have manipulated this system are the ones that are coming in and saying, yeah, it's okay to do it this way, you see, and all. This is a transferable record, and it's would be a note if it was Article 3.
for those people in Texas, if they've got a document with forged signers on it or false notarization, could they use those statutes and go into court to get that removed from their property?
Well, I don't want to be attacked for trying to say that I'm giving legal advice. What I suggest is they go and read it. Exactly. And understand it, because it's real clear. It's real clear. Just look at 51.903A.
Okay, so
that's the very beginning of it, and it goes through and explains it. It explains to them what the court will do, the whole process. It's all there. Now, on that note and all, I'd also like to say that apparently there's a revision to that that's being introduced to the Texas legislature and all to add some wording to it. Now, if people want to look at that, I believe that they can and all. But I see what they added to it would probably help those from back in the 90s. What's already in that code and all, I believe is sufficient for anyone to be able to do it, because it's something that's asserting a claim, a lien or a claim against real property.
Okay, so everybody listen up. If you're in Texas, go read those statutes right now and see if you can actually use this to remove some of these assignments off the property because of other fraud or illegal beneficiaries or the things that we've talked about. And then everybody in every other state, let's look at our codes, whichever state you're in, to see if there's anything similar to what Texas has done. We'll look in Texas to see what they're actually called. And search our statutes, because here's been the question. We find these fraudulent documents, but how do you get them off record? What's that next process? And that's a real challenge. So maybe
and from my experience, I can offer this bit of advice to it and all, is that don't be aggressive. If you're aggressive, they're automatically going to go against you. All right, it's just like anything else. Whenever someone, well, what kind of tone do you have? What I would suggest to people and all is to go down and talk with your recorder, with your clerk, because I honestly, I'll put in my experience with this and dealing with certain people and all, they're trying to understand this just like we are.
Exactly, and you've made that really plain.
We can help educate them to better understand it. There's strength in numbers, all right? And what better number could you have than to have the clerk understanding what's taking place here, so that they can better understand this and know what you're speaking about, so that they can say, hey, yeah, you're right here. Wait a minute, something is not right. Now the clerk can do something, because you can't really change public records.
Right.
That's a particular certain part of the government and all, but you can educate them with that so that they can understand that, okay, we're going to question this before it's recorded. Because most of all of this is being recorded electronically.
Exactly.
I don't see it in front of them.
Exactly. In fact,
if they're not aware of these type things, it's going to be very difficult to bring it, say, before a court or a justice or whatever to discuss this if they don't understand it.
And like you've pointed out, nobody
stands
gets
a better chance, because,
right.
like I've said many times,
right.
I do not believe that all the judges, all the clerks, all of those people that are in the office around are bad.
Exactly.
There's some bad ones in there.
Exactly.
I do not believe that I don't think that they appreciate what these bad ones are doing.
I agree with you.
Think about this. Every time that something needs to be changed, it's not until the people say something and all that those good ones come out.
That's right.
Be able to do something.
That's right. And we've
got to open the door for them in order to make changes. I'm sure they're ready and willing to do it. I'm sure they're tired of being called names.
Exactly.
I'm sure they're tired of all that. Just like trying
right.
to get out of something. No,
That's
they're
right.
trying to hold to their contracts, but yet
That's
someone
right.
else is manipulating things in such a way they don't have that ability, and they're looked upon as a deadbeat.
That's right. That's right.
You know, these investors in here, whenever they come to find out, you know, if these things failed, REMIC, and they'll read that task force. You know, I mean, they mentioned quite a few things in there about the REMICs and the IRS being able to get
Yep.
through their laws and all with that. And if they didn't, you know, those investors and all of that, you know, they're going to end up getting called bad names too. They'll call them a tax evader.
Exactly.
They were doing. They were manipulating the system and all
Exactly.
for them to make a profit, and they didn't pay any taxes upon it.
Exactly, and that's why we've even talked about having owners file an IRS whistleblower claim against the specific security in which their mortgage was securitized, if they can find that. We've been trying to, and now already today, Karen brought to other information to us about the insurance commissioners and about these indemnity agreements between who even knows who's giving this indemnity to the title companies when they're just going to not release the note, but they're just going to release the collateral with a lost note substitute affidavit that they probably paid $13 for to forge. it's just amazing.
Well, I mean, they help them word things in so many ways, and that those two patents, basically, you're looking to see how they were manipulated. All this, you know, I mean, if people are looking, you know, on this and trying to prove beyond a reasonable doubt, there is plenty of information there. Those patents show it.
Exactly.
The wording from that Texas transcript, the wording from back in the Kuna letters talking about the E-Sign Act not governing article or not being applied or excluded from the UCC, like Article 3 as far as a note, and all. How are they lawfully doing all of this to begin with, and all, and that's how you're going to end up exposing all of this, is sticking to that paper side, because they've already admitted to all the intangible. They've already admitted to their intent to
Right.
do all of these things, and it's already written. It's easy enough to say that,
Exactly.
and people go and understand, but to do it, you've got to understand that difference between tangible and intangible.
Right.
Something new,
Right.
most people don't understand. Tangible
Exactly.
it's electronic, all right,
Right.
or paper and all. Intangible is electronic. It's an electronic record. It's an electronic transaction. Those are governed by separate laws rather than those that govern a tangible negotiable instrument or a tangible security as far as that goes.
We're going to have to cut
And
this
there's
off.
a UCC that excludes all of that, because the only thing that could really be looked at UCC-wise for them would be the general intangible or the payment intangible that, you know, that they're, that's that stream from the homeowner's payments up through whoever it is to go to wherever it goes.
Right, right. Oh, Alva, we really thank you for sharing with us today, and I've got your chart up again for and I will make sure that these links are all on the comment section so people can find these charts. I have one you sent me a whole bunch, you and Joe and James, and I've got them linked on the website, and I will also include. It's occurred to me to go through that page and start just saying with these links, they planned this, and here's what they did in 2007, and here's what they did in 2008, and here's what they did in 2010. And if you can send me, and I apologize if you already have, Alvy, I can't find it, I'm swamped now with emails, but if you could send me any of the links to the 1992, those charts you were talking about, the assignments in Texas, that would be really helpful. I'll just include that as a timeline, because I think we as a nation, the people, need to have an easy place to go to say, here, just go look at the timeline. I can see myself wishing that I had this facility in explaining to other people, because like we've already talked about and discovered, this is a fairly complicated, involved, extensive time planning fraud that they've been planning for decades, and this is how it's matured. And now we're at the end of the matured cycle. The fruit is falling off the tree, and it's just banging all the homeowners on the head. It's ruined our property laws. It's ruined people's lives. It's ruined our economy, and we're all working to try to stop that.
Yes, I agree with you on all of that, but I think there's one word or two words you missed.
Okay, help me.
Civil rights. Your civil rights are being violated in more ways than one and all.
That's
and
true.
we need to understand that and realize it, because if everything was going according to the law, you couldn't even bark civil rights, so to speak, I don't imagine. But whenever you're going in and dealing with these things and they're not following the laws,
That's
you go
right.
into a court and they're acting not as the court, but as an individual under color or whatever.
Right.
There are violations of civil rights there, and there's something that needs to be done about that. And I believe that if people understand that and they start explaining that to their officials, I think they'll get some attention. Don't give up on it. Don't think that civil rights stopped back in the 60s.
Right.
They've just blinded everyone's eyes to realize it, because people see it. They say it. Why is this happening this? Well, my rights or something's not right here. Exactly.
Right. And that's another avenue that we need to expand and expound on. I agree. And before you go, Alvy, I would like your feedback on Marcy Kaptur. She's a House of Representatives representative from Ohio. She's introduced a bill, H.R. 189, I believe, where the GSEs, Fannie, Freddie, Ginnie, can no longer insure or participate in any way on any of the loans that are involved with MERS. So what do you think about that? Is that good? Is that going to help?
Well,
Any ideas?
but that's right. It's actually tough. I think that's more just a play or something. To me, it sounds like there's not an understanding, because it doesn't matter whether MERS is involved or not. Look at the Fannie Mae Security Instrument Covenant 20. It says that they can sell the note or a partial interest in the note together with the security instrument.
Right.
So MERS is not really listed in those. Like I say, if you go back even in the 90s, you'll find those Fannie Mae security instruments, Form 3044, depending on the state. But you go through and look at Covenant 20 or somewhere thereabout, you'll find that. So I think that the reason that they brought MERS in was to make it look a little more legitimate, because they needed some type of special purpose entity or vehicle for the securitization process. It would be like a bankruptcy remote, something that wouldn't fail.
But I think, Alvy, it also may be that, just like we've been saying all along, the people involved don't understand this. And I remember about a year and a half ago, the very first thing I ever heard from Neil Garfield, short little 10-minute video, I do have it linked to the website, but he talks about how they did everything backwards, and they mention it's a MERS or a MERS look-alike database process. So it, like you said, it doesn't have to be MERS. It could be something else.
No, actually, if you go do a little research and all, they were working on another electronic registry. I can't remember the name right offhand and all, but they were going through trying to put together another one. I don't know if they're still doing that or not, but they were creating another system, something similar to MERS and all. Whether it was a replacement or not, it may be. I'm not sure, but
Right.
The thing for people to understand and all is that the MERS system does not track paper promissory notes.
Right.
MERS system tracks electronic promissory notes. So why are you worried so much about MERS? If MERS only tracks that, how does MERS hold a paper security instrument?
Right, it doesn't.
So you see where that law is governing in that section, or Covenant 16, thereabout, and all that says that if any of this is conflicts with applicable law, it's not really enforceable in that. I mean, you'll have to go read the wording to understand it and all. I'm doing a little paper on that, hopefully to publish here real soon. But if you look at that and you look at that wording, whether it be MERS or it be that on partial interest in and all, you're looking at something that conflicts with applicable law. You're actually what you're doing is you're taking paper instruments and all and saying that it customers, you need to learn electronics. You need to understand the words and definitions that they use in order to ask them questions, because if they tell you the mortgage, you're going to believe that, okay, you're talking about my mortgage.
Right.
You know, and it's that old, what's that old adage they say about, you know what word assume means, right?
Right.
So that's what we should do, is not assume a thing.
Exactly.
Define it for you. Don't just, take it on their words, because that's why we've gotten the problem. They're word crafting with
Yeah.
what they've used,
Yeah.
and all it sounds so similar.
Right.
There are white papers out there that tell you that. Yeah, these words, they sound so similar it could confuse you.
Right. Right.
No, I mean, there's your
Yeah.
hint right there, letting you know that, hey, you got two words, so, let's don't confuse ourselves. And I believe if people start to realize that confusion will start going away.
Well, and one of the things that just leaps to mind about this wordsmithing is if everybody takes their deed of trust or their mortgage, that's the security instrument that connects that note that you borrowed the money theoretically with, and it connects to the collateral, the property. One of the first they redefine all the terms in that security instrument, the deed of trust or mortgage, and call it a security instrument. So it'll say deed of trust now means security instrument, and they redefine everything. It's really struck me that they felt impelled to do this. And I'm positive that there was something going on, because they were very smart and shrewd about how they tried to structure this system so that they could, basically rob us and get away with it.
Yeah, that's
My summary.
And it's sad. It's sad that these people got so greedy. I mean,
Exactly.
if anybody ever turned their back on God, these people did.
Exactly.
On them for doing it.
Yeah, the love of money is the root of all evil, and it is the love of the money and the power that brings. It has to be, because there's, like I've heard some activists say in a video as they're talking against Wells Fargo CEO, it's how much money does it take? When's enough? You guys have all the money on the planet. Isn't that enough? Why are you still taking the houses illegally? And that is the cry of the people.
Yes, it is. Yes, it is. But, I've gone through this for quite some time now. In 2007, it really all started with me. Wells Fargo started attacking me. And even though they've sold my home and they've tried everything that they can, I'm still sitting in it.
Right.
And
Good for
and
you.
I don't believe that I'm going to leave.
Good for you. Don't leave. Don't leave.
Can do it. They can come and force me or whatever, but
Yes.
they know that I know what they're doing,
Exactly.
and I'm trying like the Dickens to get it exposed so other people would know
Exactly.
what they're doing to them too. Especially this little foreclosure mill firm up in Dallas or Addison, Texas, and all Barrett, Daffin, Trappier, Turner, and Engel LLP.
Yes.
So these people have found a way to manipulate this system in such a way that it is a moneymaker for them.
Absolutely. Absolutely. And I've been asked to actually put together a presentation on how many ways they get paid. So I'm going to be soliciting some input from everybody, but to try to explain this in simple and understandable terms, how these banks never had any risk, never had any money, and yet get paid and paid and paid. This is truly the unfairness and I believe the point of why they've actually had this task force to figure out, okay, we're going to have a problem here, so how are we going to solve that? And so they already knew it was coming.
You have to go back and look too, and I'll send you a letter, because it was a letter from Tommy Bastian to the I believe his name was Wallace Jefferson, a Supreme Court justice and all, but he sent a letter in the earlier part of the year 2000 saying, hey, we need to address these things and all, and so we need to form another committee.
Wow. Well,
They worked their way to it, and even
Exactly.
through that and all, they asked to get the committee and all, and then they drug it out long enough and all, when the Supreme Court said, hey, you asked for a committee, we appointed a committee, and now you're not doing anything, why are you not? And then hence came the November 7 meeting
right.
had that, is very valuable to many if they
Exactly.
go through and read it and understand what it was that
Exactly.
they were doing. But it's the thing is that I have two copies contracts, or I'm supposed to have two contracts. I have a note, and I have collateral, a security instrument that attached
Right.
that note to secure it. And those contracts are between me and the party that's named in it.
That's right. That's
If
right.
anybody else wants to come and claim that, I need some sort of proof of that.
That's
Otherwise, why am I paying you?
Exactly.
It does not mean don't pay. It's the matter of questioning and asking these things in some form or fashion on how you can do it. Qualified written request, if you look at that with the history of people, they ignore that. I mean,
Exactly.
look at Wells Fargo and things that it's done.
Exactly.
It's ignored court orders.
All the banks have.
Homeowner think that, that they're going to make Wells Fargo move.
No.
Now, if we, the people, instead of we, the me and the mouse in my pocket,
Right.
do something together, we'll get something accomplished, and we can get them to answer that because we will put our officials, we elected, us the constituents, will force them into a corner to start doing something about this.
Right.
If we don't band together, me and the mouse in my pocket, are never going to get anywhere.
That's right. This is
And,
true.
and it goes back to George Washington's farewell address. If people want to look at that, he warned us about all this. If you don't keep an eye on these people, you're going to be surprised in the end.
Yeah, nasty surprise. Yeah, and it's never more true than now, and that is divided, they chew us all up, foreclose everybody, take everybody's property for their benefit.
Go read it.
United. Yep.
Divide and conquer. That's what they
United
want.
we can do it.
All right, let's use the same tactics. Let's divide
Exactly.
them and conquer them. Because,
Exactly.
you look at the
Exactly.
Fannie Mae lawsuit that was filed on, I think, around the 13th or something like that against all the banks. even across the
Exactly.
globe.
Exactly. And the regulators who play right along with them, and like the OCC just said, okay, banks, you disperse the money. We're gonna hold you to making some more payments, but then they're gonna let the banks decide who to pay.
I've gone through. Excuse me. I've gone through the process and all. I didn't just jump into anything. Whenever I got involved in all this, I started with my local officials. I worked all the way up through my state. And then from there, I went into the federal government. I went to HUD. I went to the OCC. I went to President Barack Obama. And actually, I posted a thing out there, fraud against the government or something, and I put up there showing an actual contract that was submitted to Fannie Mae, FHA, anyway. That it wasn't Fannie Mae, but FHA, for a HUD loan or an FHA loan, and all. And the instrument was altered. Our signatures are not on there. But yet, I showed everywhere I went. I went to the OCC. I filed a complaint.
Right.
They went to Wells Fargo. Wells Fargo said, nothing's wrong. The OCC said, okay. Then they said there's nothing wrong.
Exactly.
So it all went from a presidential inquiry. So I want people to think badly of the president with this because me, a little nobody somewhere out here, I took the time to fax and mail and email my complaint to the president to tell him about this and all. And I believe that they wanted to know something, but you've got these heads of the OCC that say, there's nothing wrong with this. I talked with HUD. Those people were actually pretty nasty with me. They thought, I'm the deadbeat homeowner.
Exactly.
To get out of something. But all I was wanting to do was hold to the contracts I was bound to.
Right, and get them to do their job.
And it didn't actually work, and all. So I published it out there to show people that, we haven't, we started in lower areas of all of this, what most people now today are probably starting out with and going through those processes to try to do this. And that's why I've come to the conclusion with this about educating those that we elected into office, because apparently they don't know. And if more of us, we the people out here, are more educated than them, they're going to start listening to us because they know that we know they don't deserve to be in office.
Right. Well, and as they start to see that the people actually care, then they'll care. And that's the point. And we're asking them to step up and do something. It's so much easier to just sit in the chair and just let the system go the way it's going and not, jump into the stream and try to stop it.
That's why we're in the shape we're in.
Yep.
But But it's sad to say, all of us are to blame. We can't, we really can't put it on anyone else, because even myself, I'll take responsibility in all this. I wasn't paying as much attention as I thought I was.
Right.
And all. But why did I need to? I was a homeowner making my payments. I'm doing everything that's required of me. And then all of a sudden, these things start happening to me, and I'm in a whirlwind trying to figure it out.
Exactly.
I spent 3 years trying to talk with Wells Fargo to get things straightened out, and they don't even have a clue of what was going on. They couldn't tell me anything. They ultimately told me they didn't hold my note.
Exactly.
Exactly. So it gets pretty crazy for people. So what we've done, because of the knowledge that the research that James McGuire has done, the education I've received through this along the way, and my research also, I'm being able to explain it in a different fashion from what it is James has already explained. But his is pretty way up there, and all of that. For many learned and educated people and all, and for peons like me, and all the laymen that really doesn't understand that unless I go get a dictionary, to help me figure out what these words mean and all. It becomes confusing, and I can see how one can lose interest and all. But it's there, and if you would get those type of mentalities out of your head and understand it, the legwork's been done for everyone.
That's right. And I really feel that it's real important that we simplify and yet document this pattern, this preparation of planning and deception that people can easily see with these articles. And this has just been fabulous. These articles just came to me this last week. It swirls around. I get so much information, and it's hard to digest it all. And that's why I'm asking for others to help me explain to the viewers and talk about it, because everyone has their area of expertise. Alvy, we thank you so much for joining us today and for explaining this.
Thank you so much for having me on. And
absolutely.
We extend the offer. If people are lost in a particular area, our email address is ready available. Contact us and all, and let us help you understand. We don't give legal advice, but we can give you an education.
All right. And I get calls all the time, emails all the time, asking for, this contact information. So if you're willing to talk to people about their situation individually, which I've pretty much lost the ability to do because I just have so many requests, I'd really appreciate, just send me your email, tell me what state or area you're in and how you can help them. And I can start to put, a database of this information together for owners, because
it sounds good. I can do that. I'm in Texas. I know the laws really well. We
That's
don't
great.
Anything else through the states and all. I think James McGuire, he can pretty much help you understand that. The UCC, but everything boils down to our local state laws. So
exactly.
State Pacific and all that, I believe we can beat these guys up.
Okay, let's beat them up. That works for me. Signing off. This is CJ and Alvy. Thanks a lot, Alvy. And I really got a lot of good feedback about our sign-off video and song from England. And so we're going to say goodbye, and we'll talk to you tomorrow. Don't forget, tomorrow is Update Friday. So let us know what's going on with you, and try to tell me today or early in the morning so that we can connect and you can get on the show. Thanks, guys. We'll see you tomorrow.
When I was a lass, I was proud of me class, like my father and mother before me.
They taught me to fight for my civil rights.
But it's always the same old story.
The rich reign supreme while the poor can but dream.
feelings get touched. Why?